that, says the Prime Minister. You stated earlier today, at the end of your testimony, that you would prefer to see NCCOP perhaps go too far rather than not benefiting from its analysis, and that this would allow for a healthy debate around the issue. So my question is this: how do you envisage the possibility of having a debate with regard to what will or was reported? The work of NCCOP is mainly based on information that is classified. So how do you view this? Response. First of all, I would clearly prefer that NCCOP be exact and precise and well-founded in everything it is reporting and putting out. We understand that this is an organization that is rather new, that's still developing its ways of doing things. And for me, a learning curve is appropriate for an institution that we hope will be in place for decades in order to defend Canada's interests. Clearly, when NCCOP made its report, I asked the Minister for Public Safety to publish a response to the report, to explain, to thank NCCOP for its work, but also to explain that there were elements that we weren't perhaps perfectly aligned on, that might have been slightly erroneous. For me, the important debate is that which is taking place within the government with NCCOP that's learning. We're saying, well, maybe the next time we shouldn't go as far. These are adjustments to be made, and you were right in underscoring this. The idea of having a broad debate, a public debate on how NCCOP is working may not be valid, but there could be articles, analysis by journalists, etc., saying the minister stated this, NCCOP said this. I think that is part of the lived experience that we must all accumulate in areas of security, intelligence, and interference. Question. I have a question flowing from your response. And I don't want to prejudge the responses. As you know, we must also look at the NCCOP report, so I don't want to prejudge the conclusions we might reach. But do you see a risk here? Were there to be errors, as some have stated or identified, or if stronger terms will be used by NCCOP or by the intelligence community? Do you have a fear that the trust of people in these institutions might be harmed by a public report that can't be necessarily corrected, given the classified information involved? Answer. It was corrected by the response of the minister, underscoring the fact that there were elements that we disagree with as a government. And this process, well, clearly we won't always have a commission of inquiry on all of these reports, but I think that the learning process throughout the process will result in a situation where NCCOP and those who take a close look at these reports will be in a better position to judge the information and the analysis provided. I think we also must underscore the fact that there is rarely a very clear black and white analyses of these types of situations. There's always an approach based on analysis, reflection, debate, such that for me, if we have a broader perspective, even if it's not perfect, especially in the first years, this allows us to develop expertise that will be stronger in the coming years. Thank you. Second question, that becomes, in fact, the third question. You indicated that we must be very prudent before regulating or legislating with regard to nomination races, etc., involving the various political parties. And you added that what's important in your mind is that the political parties take into account the rules in place and respect their rigor. Would you have a suggestion with regard to the way these requirements should be imposed on political parties? Ideally, these wouldn't be rules imposed by legislation, imposed by a government, or even by Elections Canada. These would be rather expectations on the part of citizens for oversight and accountability vis-à-vis journalists. Members of parties also should require that the party demonstrate that it is following a rigorous system in order to protect itself, in order for voters to be able to evaluate the situation. There's no way of legislating. We could ask Elections Canada to take a closer look, but there are political parties. I mentioned the Marxist-Leninist Party, for example. There are parties, as I was saying, for which the rigor in their structure might be different from what we might expect from a party that would want to form a government or hold a balance of power in the House of Commons. We must be careful when requiring certain behaviors or processes on the part of a political party. We mustn't be creating barriers to the creation of political parties in a free and open democracy. We must be careful to always allow our democratic institutions to organize themselves with integrity vis-à-vis what they want to propose or oppose for the country. I'm not saying, no, there's no way of doing this, but we must be extremely careful so as to not harm our democracy, hinder it. We must not hinder it as we seek to protect it. Thank you.
Question. So the first one is Mr. Singh for the Sikh Coalition.
Thank you, Commissioner. Mr. Trudeau, my name is Prabjot Singh for the Sikh Coalition. You spoke to Commission Council earlier about this intricate network of Canada-based Indian diplomats, senior government officials in India, and then the Lawrence Bishnoi gang, and who went on and engaged in violence in Canada. So before we move into some of the more substantive issues, I just want to clarify and confirm a couple of facts for the record. You spoke about a number of ways that diplomats covertly and illegally collected information on individuals in Canada, including threatening to revoke visas. Some of the information that was collected by diplomats was also done by coercion, including threats of violence against family members in India, correct?
I am very aware that there is an ongoing RCMP investigation and indeed trials and court cases on these issues. So I really would be hesitant to venture much further than I already have in which what I was saying was pretty much repeating what the RCMP announced on Monday. I wouldn't want to go further in characterizing things that are questions better asked of the RCMP.
Sure, that's totally fair. So the RCMP's press release and its comments at the press conference stated that organized crime was used to execute the violent activities to create a perception of an unsafe environment targeting the South Asian community in Canada. Do you recall that?
Yes.
So I think you would agree that this is quite an alarming and intrusive attack on Canada. So this goes beyond simple disinformation and amplifying narratives in the media that Canada is unsafe. These individuals and government officials actually orchestrated violence to make people feel unsafe and come to that conclusion. Is that fair?
I'd actually say there seem to be two goals in this. One is, yes, to make Canadians, particularly South Asian Canadians, feel less safe here in their own country. But secondly, is actually to help prove a point that the Indian government has been trying to make about Canada for quite some time, that we are a country that doesn't take seriously violence or terrorism or incitements to hatred, which is entirely false, but failing an ability to point out how Canada has been supposedly failing to prevent violence, it seems like folks within the Indian government have decided to create violence and unlawfulness in Canada as a way of demonstrating the point that they are trying to make, that there is violence and unlawfulness in Canada. And I think that is exceptionally egregious as an approach to a neighboring sovereign democracy.
So you also indicated to Commission Counsel earlier that the diplomats were passing informations to officials at the highest level of the Indian government, who then would pass on the information to the criminal gangs to orchestrate the violence. So given that reality, this was not just a rogue operation of a few individuals that went off track. At some level, in some form, there was a clear policy decision that was authorized and directed by responsible members of the government of India to orchestrate this violence. Is that fair?
I think that is an extremely important question. And that is a question that actually we have been repeatedly asking the government of India to assist us on. And to get to the bottom of the question of whether it is or could be rogue elements within the government, or whether it was a more systematic endeavor for the government of India, is exactly the kind of thing that for investigators here on the ground in Canada, it is somewhat removed from being able to uncover the internal machinations of the Indian government of who went wrong or who did this or who did that. That's why from the very beginning, we have been asking for India, the Indian government, to take these allegations seriously and proceed with their own investigations and work with us on figuring out exactly how these egregious violations of Canadian sovereignty actually happened.
Are you aware of public statements made by Prime Minister Modi in spring of this year where he said something to the effect of, today's India doesn't send dossiers to other countries to request assistance. Today's India will kill our enemies in their homes. Are you aware that that statement was made publicly by the Prime Minister?
That was a public statement that I am aware of. Maybe not in those exact words, but
sure,
as you say.
Something to that effect. So you spoke earlier about the geopolitical instability and context that we exist in right now and how it intersects with different foreign interference threats. So I think you would agree that the Modi government's autocratic behavior in terms of these specific violent acts that have been carried out over the past year or two is a threat not only to Canada's sovereignty and institutions, but a very real threat to the international rules-based order itself?
One of the reasons we have been so deeply engaged with our allies, particularly our Five Eyes allies of the United States, the UK, New Zealand, and Australia on this. We are a tight security partnership, us 5 countries, but also others, is because we are seeing right now around the world a pulling back of the rule of law, contesting of the international rules-based order, whether it be Russia's illegal invasion of Ukraine, whether it be China's coercive diplomacy, as evidenced by the arresting of the arbitrary detention of 2 Michaels. Ensuring that amongst our community of nations, particularly democracies, that purport to be and aspire to be rule of law countries, that we be there to highlight and stand strongly against violations of international law is really important. So this is something that we have highlighted to allies, and it's something that many countries around the world share of concerns that if we don't have the rule of law and the international rules-based order at this particular complex moment in global history, then everyone becomes less safe, and everyone is poised to suffer either economically or worse.
So that's a helpful kind of exposition on the rules-based order in general. The question was whether India's violent activities and attacks against Canada and Canadians, you would consider them a threat against the rules-based order and stability on the geopolitical stage,
I think
specifically with relation to these acts.
I think I have been very clear that Canada, as a country of the rule of law, will always stand up for the rules-based order, regardless of whether it is the arbitrary detention of 2 Michaels by China or actions that that the RCMP highlighted earlier this week that involves India government engaging in facilitating violence in Canada against Canadians. This is something we will always take very seriously.
So a significant amount of attention in the government's communications this week focused on disrupting India's capabilities. But in the context of a sustained campaign of violence that lasted at least a year, I would suggest that accountability for those responsible is crucial to deterring this kind of violence. So my question is about what steps Canada can and will take to ensure that the senior officials who actually orchestrated and authorized this are held accountable. Will Canada apply targeted sanctions against RAW, India's intelligence agency, as well as those officials found to be responsible in an investigation, in order to push India to cooperate?
The primary driver of the government's actions in this case, and in most, if not all cases, is ensuring the safety and security of Canadians. That is one of our top foreign policy goals, always. And we will continue to look at things we can do to ensure that Canadians are safe in Canada and when they travel overseas. Many of our foreign policy positions have flowed from that, and that will always be the lens with which we look at any possible future decisions. And I'm not going to hypothesize about what steps we might need to be taking to keep Canadians safe. What I can say is the steps that we have taken so far have been focused on ensuring greater safety for Canadians, ensuring our ability to keep Canadians safe by disrupting networks that were causing significant violence to Canadians.
So I don't think that really answered the question about accountability, but I'm going to move on.
Yeah, that's a good idea.
You mentioned Prime Minister Modi's comments to you in September 2023, urging Canada to arrest people who are outspoken against the Indian government. We've also heard evidence from SITE, from RCMP and Global Affairs that India seeks to influence Canadian policy to criminally prosecute Sikhs who advocate for Khalistan or otherwise criticize India. So yourself and the other witnesses have rightfully insisted that Canadian agencies already investigate any criminal activity, but that lawful political advocacy is protected by the Charter. So given that fact and that India engages in foreign interference with the objective of influencing Canadian policy in this regard, would you support suspending intelligence and information sharing agreements signed in 2018 that can be misused by the government of India to target Sikh activists engaging in lawful advocacy for Khalistan?
Let me be very clear once again. Canada's policy is around one India. We believe in the territorial integrity and the sovereignty of India. We respect that. We certainly expect India to respect the sovereignty of Canada, which in this case they have not. It is also extremely important that people who come to this country from every corner of the world understand that they are free to hold the political beliefs that they choose to when you're in Canada. We have a charter that protects people's freedom of expression, people's freedoms of political views. And that is not just a foundational principle of free democracies all around the world, but it's particularly important for Canada, that is a country to which people have come from every corner of the world, in some cases choosing to leave their home country because of political disagreements or other reasons. So defending the rights of people to hold political views that may be unpopular in their home country is a foundational responsibility for any Canadian government.
So will you consider suspending those intelligence and information sharing agreements that can be misused by the government of India to target Sikh activists, particularly considering the evidence we've seen that India engages in foreign interference and disinformation for that objective?
As I've said a number of times, we are not looking to provoke or create a fight with India. The Indian government made a horrific mistake in thinking that they could interfere as aggressively as they did in the safety and sovereignty of Canada. And we need to respond in order to ensure Canadians' safety. What other steps we will take will be determined in due course, but every step of the way, our single overarching priority is ensuring that we are keeping all Canadians safe.
So we heard this week that 6 diplomats have been expelled from Canada and sent back to India. But given the long history of Indian foreign interference, the intensity we've observed and learned about through this commission, and the fact that this appears to be, in some form, a conscious policy decision by the government of India, I think it's reasonable that there's concerns that when new diplomats come to replace those ones, that there's concerns that they might continue to engage in similar kinds of activities. So looking back at India's foreign interference activities, which have clearly escalated, I want to look forward and ask you to provide some insight to the Commission, because I think it's fair to say that the Government of Canada and Canadian agencies failed to detect India's activities before they occurred, before the assassination of Bhai Hardeep Singh and this campaign of violence. And whatever steps have been taken failed to deter India from continuing to engage in violence against Canada and in Canada. So can you provide some insight on what lessons you think have been learned by the government and agencies that can actually inform how Canada increases its capacity to detect that kind of activity and actually effectively deters it in the future?
Well, first of all, let me say that the issue of the Indian government as a possible source of foreign interference is not something that only appeared over the past weeks or even over the past year. Canadian intelligence agencies have been collecting that information for a number of years now. And as I said in an earlier answer this morning, we are constantly adapting and adjusting to shifting approaches by other states as they engage through different technologies, through different means, through different vectors into advancing their aims in Canada. And we will continue to learn and adjust as necessary to do what we must do to keep Canadians safe, to protect our institutions and our democracy.
Madam Commissioner, with your leave, I have one final question, if that's possible.
No, because you're 2 minutes over your time, and we have many this afternoon.
Thank you. Those are my questions.
Thank you. Counsel for Michael Chong.
Prime Minister, my client was here in September and gave evidence to the Commissioner. And one of the concerns that he expressed is that this country has become, in his words, a playground for foreign interference by states like PRC and India. Mr. Mendicino was here last week and disputed that phrase, playground of foreign interference. Given the revelations by the RCMP and by you, sir, on Monday, isn't Mr. Chong's assessment closer to the mark than Mr. Mendicino's?
No, I think it reinforces how wrong Mr. Chong is, because what this week has been all about is demonstrating the capacity and the reality that Canada has been both detecting foreign interference and acting on it. I would suggest that knowing about this and revealing it to the public and creating diplomatic malaise, to put it lightly, is an example of us pushing back strongly against attempts at interference in this country.
Not just attempts, sir, successful interference.
Yes.
You confirmed this morning that your government's assessment of the PRC's targeting of Michael Chong and his relations in Hong Kong is not foreign interference, but is instead lawful diplomatic activity. Sir, there were, in 2021, 4 intelligence products. We've only seen one of them, but there were 4 concerning PRC activities directed at my client, all coming from CSIS. The one that we've been able to see in some unredacted form is the famous IMU from the 31st of May, which I expect you've seen before. It says explicitly that CSIS regards there as being multiple threat actors, including the Ministry of State Security. Are you aware of that, sir? I can show you the document if it helps, but you may be familiar with it already.
Commissioner, sorry, just before the Prime Minister answered, my friend said you confirmed this morning that the PRC's targeting of Chong was not foreign interference. My recollection is the Prime Minister testified that Zhao Wei's targeting of Chong was not foreign interference. So I believe that was the evidence the Prime Minister gave, but I stand to be corrected by my friend.
Yes. I was talking about Zhao Wei.
Yeah, it's much of a muchness to me, sir. So my point is this. The Ministry of State Security, you're familiar with that agency?
Yes.
Is there any such agency in this country?
I think drawing parallels between Canadian structures and the PRC structures is extremely difficult at best.
Yes, particularly in the case of the MSS, because it's a foreign intelligence agency and we don't have one of those, right?
We have an intelligence agency that focuses on collection internationally, which is CSIS.
Right, right. But we don't send spies abroad and we don't send secret police abroad. Isn't that right, sir?
I'm not going to speak to CSIS operations, but I can tell you there are CSIS employees all around the world.
Sir, my point is this. The MSS is PRC's...
Or I'm missing something about
well, let
what
me get to
CSIS
it.
does.
MSS is PRC's equivalent of Russia's FSB or the Soviet Union's old KGB, or indeed India's RAW, the Research and Analysis.
Or the U.S.'s CIA.
Right, we don't have anything like that. My point, sir, is that if a diplomat, a so-called diplomat, Wei Zhou, in this country is sending information about a Canadian MP, 2 Canadian MPs as it turns out, back to MSS, not back to the foreign departments, not back to foreign affairs, but to China's spy agency, that, sir, is not lawful diplomacy. Don't you agree with that?
Oh, yeah, I'll say 2 things about that. First of all, I'm not entirely certain that you understand what CSIS is, if not Canadians' agency for collecting intel overseas. And secondly, in terms of the analysis of what Zhao Wei or others were doing, I am obviously not an expert in the hierarchies within the People's Republic of China's various agencies. But what I can say is I defer to CSIS's conclusions on these because they are the intelligence agency that provides me information, provides us information on foreign activities, particularly bad actors. CSIS's conclusion in this case that we've seen before this commission is that the actions that Zhao Wei engaged in regards to your client did not constitute foreign interference. Now, I am reporting that. I am not the person who made the analysis and determination that it was on one side of the line or others. I have confidence in our agencies that do make that determination, however. Sir,
Zhao Wei was not a lawful diplomat. He was a foreign intelligence agent. He was a Chinese spy. Do you accept that?
I accept when I will state that he was ejected from Canada because he was no longer able to even carry the role of diplomat, which was his overt role. But I also explained that there were situations in which CSIS has concluded that he engaged in foreign interference activities, albeit not towards your client, Michael Chong.
So I put it to you that Zhao Wei was outed as a foreign spy, not by your government, but by the Globe and Mail.
There is no question that the criminal who leaked the information to the media had a role to play in our decision to expel Michael Chong. But as I said, expel Zhao Wei. But there were 3 factors that went into that decision to declare him persona non grata. One was the escalating tensions between Canada and China, where they, despite repeated attempts, refused to decrease or stop their interference activities. 2 was the fact that Zhao Wei was indeed, and this perhaps goes to your contention, was engaged in foreign interference activities, albeit not towards Michael Chong. And 3 was the fact that his name was plastered across the newspapers, made it impossible for him to continue to be a diplomat in Canada.
NSICOP reports that CSIS identified Zhao Wei as a candidate for expulsion in 2019, several years before the Globe and Mail story. But your government let him stay here. Nothing was done about him, and you, on your own evidence, had never even heard of him until you read about him in the Globe that morning. I put it to you, sir, that as head of government, you ought to have known who Zhao Wei was and what was going on. Should someone not have informed you about his activities?
As I've said a number of times, in my role as Prime Minister, I need to know the behavior of China. I need to know the behavior of India. I need to know the behavior of Russia in regards to Canada, in regards to Canadians, in regards to Canadian interests. I do not need to know the operational details to be able to establish and empower the agencies to actually go after that. Now, I need to know the type of things they are doing, but knowing the actual name of the individual, there are such a large number of names that I trust and count on my intelligence agencies to do the follow-ups on the dozens of diplomats that they must keep a close eye on across the country at all given times. And me sitting with a list of names of potential problematic people does nothing to help keep Canadians safe in the role that I have.
But, sir, it goes well beyond particular names, because what you weren't told was that there was a debate raging in your government between CSIS on the one hand and Global Affairs on the other. CSIS assessed that these activities, we see it in the 2021 IMU, were threats to the security of Canada. CSIS conducted a TRM of Michael Chong on the 2nd of May for that same reason. Meanwhile, Mr. Morrison...
Excuse me, it was not a TRM.
It was a defensive briefing, actually. I misspoke this morning, so you caught me on that. It was a defensive briefing to Michael Chong, not a threat reduction measure, which is apparently an important distinction, but...
Well, I'll leave that for now. I thought Mr. Chong's evidence was that he was informed by CSIS was a TRM. In any event.
That was after the leaks.
That's what I'm talking about.
Okay,
yes.
I believe that was a TRM. It was the earlier ones that were defensive. On the 2nd of May, 2023,
that was a TRM.
2023, yes.
Precisely. So you've got the security service on the one side assessing that these are foreign threats, this is foreign interference. You've got Mr. Morrison and Jody Thomas, Global Affairs, saying, no, you've misunderstood, this is consistent with the Vienna Convention. What you ought to have known, but were never told, sir, was that there was this debate going on and that it was causing disagreements between agencies about how to properly analyze and characterize particular instances. Michael Chong happens to be one. There may very well have been others. Someone ought to have told you that. And so I want to push back on this notion that we've heard from other witnesses. And
actually, let me push back on that right there, that I testified earlier today that I am fully aware and indeed regularly apprised of tension of constructive, creative tension, of disagreements of perspective between diplomats and spies, or between our Global Affairs Canada and
But sir, no one told you before May 2023 that there was a dispute in your government about whether Zhao Wei was acting lawfully or illegally.
Right, not about this particular person,
point.
But about a range of diplomats from many different countries who are engaged in questionable activities that we have to make determinations around which ones and when we kick out, knowing full well that as soon as we PNG anyone, we lose diplomats on the other side who are not engaged in subterfuge. So there are many factors that go into when one takes a PNG decision. If we were to kick out every single diplomat who raised concerns, we wouldn't have any diplomats and therefore no representation in any of our adversarial countries. And part of diplomacy is making sure that we do have people there, and the price of that is having people here. Now, what our intelligence agencies are constantly doing, as you're pointing out, is keeping an eye, metaphorically or actually, on many of these people, while engaging in an ongoing dialogue, sometimes a debate, with Global Affairs Canada to ensure that we're getting that balance right of protecting Canadians and allowing the work that Canadians are doing overseas in these countries to continue to further protect Canadians.
Sir, you've characterized this debate as a good thing in your words this morning. Other witnesses have come and called it a healthy debate. I want to suggest to you that it wasn't a healthy debate. Having a debate about what foreign interference means and where the line is between that and lawful diplomacy is fine to a point. But at a certain point where one of your agencies is saying one thing and the other one is saying the other, someone has to come to you as the head of government and say, say, we have this dispute. It's causing us trouble in operationalizing particular instances, my client's instance being one, but no doubt there were others. Someone should have come to you, the NSIA should have come to you and said, Prime Minister, we've got this difference of opinion. We want you to know both sides, and we need your guidance. But no one ever did that, and so you were left in the dark.
But that is exactly why the authority for P&Ging someone rests in the Minister of Foreign Affairs' office, and she was very much closer to this debate because it is her responsibility. And when the decision was elevated to, okay, we should possibly and probably P&G this individual, then I was brought in as part of the discussion around that, recognizing that it was her authority to do.
Sir, when the story came out in the Globe and Mail, Mr. Morrison explained to us that Global Affairs went back, looked at its records, found that, in fact, CSIS had been raising alarms about Wei Zhao's activities years before, but they had never, in Mr. Morrison's words, moved beyond the working level, meaning they somehow had not come to the attention of leaders within Global Affairs. So again, I say to you that this is a failing of this government to take serious situations and serious debates about what's foreign interference and what isn't, and actually resolve them. It's all well and good to debate them, but at a certain point, a judgment has to be made, and someone has to give governance and guidance about how things should proceed. And that wasn't done until we read about it in the Globe and Mail.
On the contrary,
2nd of May.
Choosing to not act is a judgment. The fact that it wasn't determined in those previous moments that the threshold for P&G had been met was an active decision. Yes, you can act by P&Ging someone, but you can also act by saying, no, we're going to keep this individual under surveillance. We're going to keep keep them within what we know. I can't speak to whether or not there is active surveillance on any individual or not, but continue to be aware of this individual and what they are doing, because it has purpose. Finding out when that right line is and when that moment is not something to be taken lightly, and it is something that rests on the collected and collective expertise of people who've been working in the security and intelligence domain for years to develop the expertise on when that timing is right.
Sir, it wasn't a matter of you choosing not to act when it came to Wei Zhou. You didn't know you had a choice before you at all.
But the act is not mine. The act is not mine. I do not determine when someone should be.
Well, the same goes for Madame Joly.
Then you can ask Madame Joly about that.
Just a moment. I think just wait for him to answer. And same thing on your side, just wait for the question.
We go back to debating days at McGill, so there's a little bit of back and forth there.
My point, sir, was that there's no evidence that this was put before Madame Joly or whoever the foreign minister was at the time either. It all came to a head because of the leak. And what I'm suggesting, you have rightly said, that the leak is criminal. Absolutely right. Should not have happened. But this debate, which I say is not healthy, but was festering in your government, boiled over with someone taking the law into their own hands, what they ought never to have done, and revealing all this to the world. And only then did you react. There was nothing proactive. That's my concern, sir.
Well, the issue with the criminal who leaked this information is they got it wrong in what they leaked. And regardless of what's in the newspapers or not, it is incumbent upon a serious, responsible government not to react to partisan attacks or erroneous but salacious headlines, but to react on the substance of things. And that's exactly what we did when we, as a government collectively, in the person of the foreign minister, made the determination that it was time to P&G Zhao Wei.
So you seem to be suggesting that Michael Chong overreacted in worrying about his relations in Hong Kong?
No, not at all.
Well, that is what you're suggesting.
No, I am suggesting that confronted with or faced with a leak that is itself erroneous, that suggests that China has threatened with violence his family, as the inference of the leak and the subsequent headlines were, Mr. Chong had every right to be concerned and even outraged, as did everyone, as were we, by the idea that his family had been threatened with direct physical violence, which is what the leak and the leaker suggested. We now know that that is wrong, and that is why it is really important that governments act based on actual analysis and actual intelligence and evaluation of that intelligence, and not just what appears, as you say, in the Globe and Mail.
Well, sir, I told Mr. Clow this yesterday, and I'll say it to you. Mr. Chong does not share your seeming confidence that his relatives in Hong Kong will never be coerced or threatened or even physically harmed by that state. It is not a rule of law democracy. It is not a state that has a track record of respecting people's freedom of conscience, freedom of political thought. And so these concerns that he has, whether they are based in intelligence that was misinterpreted in the Globe and Mail or not, are legitimate and fair, and you seem to be wanting to downplay them, and I want to push back on that.
I am not downplaying them in the least. What I am saying is, as a responsible government, as a government that is making decisions about how best to protect Canadians, including and especially parliamentarians, we need to rely on the best intelligence and evidence and analysis and recommendations of our security agencies. And that is what we have leaned on in terms of concluding what threats were there on Mr. Chong and what positions and postures we should take because of it. We are a country that leans on its intelligence agencies, not on criminals leaking things to newspapers.
One final point, sir. The evidence repeatedly has been that other parts of the government have not relied on CSIS's warnings. In fact, the Minister of Public Safety doesn't even seem to have received them, or certainly didn't read them. The same is true of the NSIA. The same seems to be true of the Clerk of the Privy Council. So it's all well and good for you to say we're a country that respects our security agencies. The evidence, sir, has been that the security agency has been sidelined, and the concerns it's been trying to raise have been neglected and sometimes not even read.
I think much of what we have demonstrated through this commission as a government is that we have taken seriously from the very first day threats to national security through creating things that Mr. Chong was opposed to, like the National Security and Intelligence Committee of Parliamentarians. But I would suggest if Mr. Chong wanted to be part of an organization that was taking security seriously, he implore his leader, Pierre Poilievre, to get a security briefing so he can hear directly from CSIS on the challenges threatening his institution, the Conservative Party of Canada.
I'll take that advice back to him. Thank you, Prime Minister. Thank you, Commissioner.
Thank you. Next one is Council for Andong.
Commissioner, we have no questions for the Prime Minister. Thank you very much.
Thank you. Council for Erin O'Toole.
Thank you, Commissioner. My name is Tom Jarman, a counsel for Erin O'Toole. I'm going to start with a question to which I expect your counsel will object, but it's a process we have to go through. So Section 21 of the CSIS Act creates a statutory process whereby the agency requests the minister to approve an application to federal court for a warrant. And in the course of that warrant, it's supported by an affidavit. That affidavit sets out the affiant's knowledge of the target and the affiant's reasonable expectations of the names of the individuals whose communications will be intercepted. I'll ask you, first of all, has anyone ever advised you of the name of an individual who's been mentioned in a warrant?
We would object to the question on the grounds of national security confidentiality in line with the objections made yesterday to the same question.
I've actually got a question for you, sir. In your reading of that specific act, what is the role of the Prime Minister in the granting of warrants for CSIS?
Well, in fact, I was going to make that point, is that neither the Prime Minister nor the Prime Minister's office is named in the CSIS Act or is even part of the warrant process. And so the question we're seeking to have answered is whether or not that information was passed on to your staff yesterday and yourself today. But I take the objection.
So the question is no.
Thank you. And I'd like to also the follow-on questions, who passed on the information, the context of the discussion, and what was done with that information, if the answer is yes. Thank you.
So it's noted.
We maintain the objection.
Yes, I appreciate that. In the course of your direct examination this morning, Commission Counsel took you to 3 items in which permission of yourself was sought by CSIS to brief parliamentarians. And for one reason or another, that issue never rose to your attention. And I guess the first question I would ask, to use your own words, what can the public service conclude when your office refuses to decide something? Because choosing to decide is a choice.
Well, first of all, in terms of those 3 instances, the third instance never actually materialized, so it's not an issue. The first instance got interrupted by the pandemic after a few months, and I think everyone can understand that. And the second instance, as my staff testified to yesterday, was busy being worked on by my staff until the point of the election call. They actually had, my office had questions back on that referred to briefing of non-parliamentarians who would be in an important role. So it was being worked on and didn't end up getting to me as the staff testified yesterday.
And in fact, this morning you said that the CSIS could well have gone to the Minister of Public Safety to have raised these matters with him because they had direct access to him. Is that that's consistent with your recollection?
Yes, the Minister of Public Safety is the minister responsible for CSIS, and they have regular meetings.
But I put it to you that this is just one instance of a pattern throughout this file in which CSIS doesn't go to the Minister of Public Safety. It goes to your office to seek approval with respect to matters. Is that accurate?
I'm not I can say with clarity that CSIS usually and often does go to its ministers. There are moments in which CSIS works directly with my office or orbit in the person of the National Security and Intelligence Advisor, but it is all part of the work that CSIS does.
There are at least 5 occasions that we're aware of where approval has been requested by the public service of actions either by your office or by Minister Blair or by Ms. Astravas. And the issue is raised, well, the public service didn't come back and raise the issue again. Is that actually a justifiable response when the public service asks for a decision?
Given the volume of work done by the public service, the number of requests to go through, it is usual for something that is particularly urgent or important to be elevated by the asking department when a certain amount of time is taken on responding to a file. As I said, the clerk raises that to me. The NSIA could raise that to me in any of our regular meetings, just like CSIS could raise it with the minister.
So if they don't ask twice, it's not important?
No. If they find that the usual course of affairs is taking longer than is necessary or than would be optimal for this particular issue they're concerned about, they will flag it and it will be prioritized.
I assume you've reviewed the Commission's first phase report and would agree with me that, in fact, foreign interference has been a serious problem in Canada since at least 2019.
Yes, that's why in 2018 we actually took a significant step on foreign interference and created the G7 Rapid Response Mechanism. This is something that we've been working on from the very beginning in terms of protecting Canada's democracy and national security.
So I'm going to touch on something that Mr. Van Oort raised, but from a different perspective. We've heard evidence from Mr. Morrison, Mr. Vigneault, and the Deputy Ministers of Public Safety about this conflict of views about what exactly constitutes foreign interference. If it's been a problem for 5 years, why does it take until July of 2024 for the deputy ministers to sit down and come to a common understanding of what foreign interference is?
Because when it comes to a matter like foreign interference, it is one thing to have a clear definition, which is actions of a nature that are either clandestine or illegal or covert by foreign government agents on Canadian soil or in Canadian institutions. It's another thing entirely to make informed judgments around whether something is simply interference, simply influence, or interference. And those debates they're not a bug of the process, they're a feature of the process. They are essential to continue to make sure we are adjusting to the new technologies, the new vectors of interference, the new realities as more countries do different things and other countries do less.
Forgive me, Prime Minister, maybe I just don't understand, but since 2019, this has been a serious problem, and it's only in July of 2024 that the senior deputy ministers on this file are sitting down to come to a common understanding of what particular instance are foreign interference. And in fact, they never raised the issue with their ministers.
I completely object to your characterization of this. We started to become preoccupied with foreign interference during the 2016 U.S. presidential election, where it was obvious that foreign interference was a reality. We then saw it in the Brexit referendum in the UK. We saw it in the 2017 French presidential election, which is why we built the site task force and the panel of 5 to be able to defend Canada's election integrity and ensure that the subsequent elections in Canada in 2019, 2021, and all future elections are free from the foreign interference that impacts their outcomes. That is why we have taken, that is a demonstration, and there are many more, of how we have taken seriously foreign interference from the very beginning. Like G7 in 2018 had a significant mechanism created around that, and we've continued to do more and more on that. So I can't speak to some meeting of deputy ministers that may or may not have happened at the right time. That is something for the officials involved to ask about.
Well, I appreciate that the government is using the word foreign interference with respect to its discussions from 2016 on. But if there's not a common understanding about what those words mean, how can the government be actually doing anything?
I'm sorry, at the danger of repeating myself, when we created the rapid response mechanism for the G7, to be housed in Canada around our 2018 Charlevoix G7. There was a clear understanding that acting against foreign interference was a goal that we set out and actually took concrete action on. So I would completely refuse your contention that we didn't know what foreign interference was and weren't acting on it from the earliest days of this government.
I'll conclude with this question. When there's this fundamental disagreement in 2022 between Mr. Morrison, who at that time was acting as our NSIA, and Mr. Vigneault, who was the director of CSIS, about what constitutes foreign interference, why wasn't the issue raised to the Minister of Public Safety and the Minister of Global Affairs to sort out?
I don't know that it wasn't raised. I can certainly say that discussions around foreign interference were ongoing within many departments in this country, in this government, particularly those of foreign affairs and public safety, as well as being raised within my office and at PCO.
Well, there's certainly no evidence of that dispute being raised in the disclosed documents, sir. Thank you.
Thank you. Mr. Chaudhry or Ms. Kakar for Jenny Kwan? It's Mr. Chaudhry.
Thank you, Commissioner. Prime Minister, good afternoon. Prime Minister, I'd like to ask you some questions about a different topic, and it's about foreign interference in political party nomination processes. So it picks up a bit on some of the points that Ms. Chaudhry made and also the Commissioner raised with you when we came back. And so I'd like, if we could, to take the Prime Minister to Witness Statement 106, to PDF page 10, and particularly to paragraph 36. Mr. Prime Minister, this is one of your statements. So, great, thank you. So, Prime Minister, your evidence here is that you noted that political parties are not unique in their vulnerability to foreign interference from hostile actors. Universities, research institutions, and businesses are also targets. And so I want to dig into that a bit and ask you a question about that statement. And so in your testimony this morning briefly, and also I think a bit more in your witness statements, you talked about Bill C-70, didn't you?
Yes.
And I think it's fair to say that you'd regard Bill 70 as, let's say, a signature piece of legislation from your government on foreign interference.
Anytime we, as a government or as a parliament, pass measures around national security, they tend to be significant.
So with leave of the Commissioner, I've advised our friends from the Department of Justice regarding this. I hope they don't object. I'd like to take you to the version of Bill 70 we have in the database, because there's a provision about it that I'd like to ask you about if I could.
It's fine if there's no objection.
No objection.
Yeah, thank you. And so it's Commission 382, and in particular, it's a long bill, as you know. And so it's page 37 that I'd like to go to, and it's the part of it that there's a heading on that page which is political interference for a foreign entity. So if we could go to section 20.4. Yes, and so Prime Minister, I imagine it's been a while since you've read this, so I'd like you to refresh your memory. So there is 20.4 sub 1 creates a new offense, which is titled influencing political or governmental processes or process. And that's the phrase I want to ask you a couple of questions about. It's the phrase a political or governmental process, and it actually appears in that provision 4 lines down. Do you see it?
Yes.
And I know you're not a lawyer, but you are a member of Parliament, and this is the bill of your government. So,
yes.
so I'm going to ask you the best I can about this provision. And so if we could scroll down to the next page. The term, there's some definitions here, and if we could scroll on a bit more, please. It's great. That's terrific. Thank you. And so there's a definition of what a political or governmental process is, and so it's a 6-part definition. But what I want to draw your attention to, Prime Minister, is that it includes in that definition not just the holding of an election, so electoral interference, let's say, would be captured by this, but also the nomination of a candidate or the development of an electoral platform by a political party. Do you see that?
Yes.
Okay. And so I'd now like to take you away from this document and take you to the NSICOP report, which I know the Commissioner also asked you about. And this is Commission Document 363. And if we could please go to page 38 of the PDF. And paragraphs 69 to 70. So that's perfect, thank you. And so Prime Minister, just to confirm, you have read the NSICOP report, is that right?
Yes.
Yeah, including the classified version?
Yes.
Okay, and so these paragraphs, 69 and 70, appear in a section called Exploiting Vulnerabilities in Political Party Governance and Administration. And so I just want to confirm, have you read this part of the report?
Yes.
Good. And so I want to ask you a couple of questions about it, if I may. So is there any reason to disagree with NSICOP's conclusion at the beginning of paragraph 69, and I'll quote, which is that foreign actors covertly supported or opposed candidates by exploiting vulnerabilities in political party governance and administration.
Yes.
You disagree with that?
Yeah.
Could you give me a bit more detail?
This is a very general and broad statement that that from the CSIS analysis that I've seen, there have been instances where yes, we know that there were attempts at foreign interference in various political party processes and nominations, and that's something that we talked about in the last public hearings as well. But I tend to disagree with the word exploiting vulnerabilities in political party governance administration. Not that there aren't vulnerabilities in everything, but that emphasis makes it seem like some of the choices that political parties have made are only vulnerabilities and not strengths within the political process.
Well, so, Prime Minister, there's a couple of follow-up questions I want to ask you about your answer, if I may. So the first is, I saw your evidence in the witness statements. It wasn't discussed this morning, but I think it's fair to say that the view you expressed is that any regulation of internal political party governance has to accept that there's a trade-off between hardening those institutions and processes, to use a security sector term,
yes,
and dampening participation and inclusion.
Yes.
That's fair,
yes,
correct?
Very much.
Right. And so, but the framing of that trade-off in your evidence does concede that that hardening might need to be done because those institutions do have vulnerabilities. Isn't that fair?
Yes, which is why I lean heavily towards the hardening being done by the political party itself in an open, responsible, and transparent way, rather than have external bodies come and try and constrict or limit the operations of a political party.
Good, and we'll get to that just in a minute. But before we do, there's another follow-up point I want to make, and then I want to ask you some questions here about these paragraphs. So you did point out that NSICOP relied on CSIS intelligence products in reaching this conclusion. I just want to...
And in some cases extrapolated a bit from CSIS products.
Fair, and Prime Minister, as you know, I can't ask you a question about that. But
CSIS testified to the fact that there were inconsistencies and inaccuracies in the NSICOP report.
With respect to specific allegations involving parliamentarians, but not specifically about these paragraphs,
because they weren't asked to weigh in on these.
Sure, and so we don't know what their view is on these paragraphs.
You don't.
Yeah, I don't. And I take it, well, unless you're telling us they do, I don't think we have evidence from CSIS. I'm not able to talk to that. So let's leave it at that, shall we? And so Prime Minister, just for the record, there are footnoted CSIS reports or intelligence products from 3 different years that are relied on by the NSICOP in this section. You agree with that?
That sounds reasonable.
Okay, and so what I want to do is to ask you some specific questions. So about what NSICOP represents as vulnerabilities, and to ask you whether you agree or disagree. So the first vulnerability NSICOP identifies is in paragraph 69. It's 5 lines down, and it says, first, many ridings are considered safe seats, so winning the nomination is akin to winning the subsequent election without having to interfere in the election itself. Do you agree or disagree with that statement?
Well, that there are fewer of them in the case of my own party, but there are safe seats in the country.
And the statement that NSICOP makes is
that was a joke. You guys can laugh.
Because there are safe seats, interfering in the nomination makes interfering in the election for that seat unnecessary. Is that a fair? That's what NSICOP's view is. Do you agree with that statement? Yes or no?
I wouldn't characterize how foreign governments would choose to interfere or not, or whether it's worth interfering in one place or not. There are many different goals that they might have, so I'm not entirely sure of what you mean by the question.
Okay, well, I'm just asking if you agree with NSICOP's statement there, yes or no. It's a simple question.
I agree with the first part of it. Many ridings are considered safe seats, so winning the nomination is akin to winning the subsequent election. If you put a period on that one, I absolutely agree with that statement. The without having to interfere in the election itself isn't, putting my English teacher hat back on, isn't necessarily, makes a whole bunch of sense as a sentence out of the context of the rest of the paragraph.
Well, Prime Minister, I'm not NSICOP, just as you're not CSIS, but I think we can say that for the record, I think NSICOP was saying that if the nomination is really what's at issue in a seat, if a state interferes with that nomination process, it needn't interfere in the election itself.
If it interferes successfully in getting the outcome that they are trying to achieve, then yes, if it's a safe seat, whoever ends up getting the nomination has a better chance than expected to win the seat. Yes.
Fair. So let's go to the second vulnerability of the three that NSICOP identifies. Second, nomination processes are not directly regulated or safeguarded by federal, provincial, or territorial legislation enforcement bodies, such as the Commissioner of Canada Elections. And so that's the second statement they make. As a result, the likelihood and consequences of the detection of such activities are low. Do you agree or disagree with that statement?
I disagree with that statement.
And why do you disagree with that statement?
Because political parties, where I can specifically speak for my own, the Liberal Party has established a very robust system of overseeing nominations, particularly contested nominations that often happen, as you point out, in safer seats where it is expected that whoever wins the nomination has a unusually high chance of becoming the MP in that seat. We have had to develop over the years, particularly in 2015, where all of our nominations were potentially open nominations. We had to develop very rigorous processes, and not uniquely or only or even specifically to counter foreign interference, but to make sure that that various outside groups or community organizations who would mobilize individuals were doing so in a way consistent with the rules of both Elections Canada around financing, because there are rules around nominations around the money that goes into nominations, but also the rules of the Liberal Party around who can be a member, who can vote, and who's eligible to vote.
Well, then that actually leads to my next question, Prime Minister, which is in paragraph 70. If you look 6 lines down, NSICOP reports the following. It says, CSIS assesses that it is relatively easy to fraudulently add voters who live outside a riding to a nomination process's voter list with inaccurate addresses. It is also reportedly relatively easy to show an altered phone bill with the wrong address or a fraudulent letter from a school in order to vote in a nomination. Do you agree or disagree with that statement?
That issue of accurate or inaccurate addresses is something that comes up not just in the context of foreign interference, but in the context of the push and pull of internal party processes where one candidate who is keen on winning the election may try and bring in people who live outside the riding, which means that we have developed, not infallible, but strong processes whereby we oversee, the party oversees the registration process and also has the possibility of legal counsel for the various candidates to oversee the nomination process and challenge the result if they feel that it was contested contested. So we have structures in place in the party to oversee that. Now, can those structures be strengthened? I have no doubt, and this is something that I'm entirely open for parties to be working with CSIS and the Commission on. What I will say is, I'm speaking right now to the way the Liberal Party manages contested nominations. I have no idea how the NDP or the Conservatives manage their contested nominations, and perhaps having the Commission look into a certain amount of transparency on that by the parties might be a good idea.
Commissioner, I have many more questions, but I'm out of time. Prime Minister, thank you.
Thank you. So, Mr. De Luca for the Conservative Party.
Good afternoon, Prime Minister. Am I correct that you have top-level security clearance in government by virtue of your office?
Yes.
Do you know which minister is responsible for the communications security establishment, sir?
Yes.
Minister of Defense?
Yes.
Do you know Ms. Zita Astravas, sir?
Yes.
She worked on each of your Liberal Party election campaigns in 2015, 2019, and 2021, correct?
I believe so, yes.
And she worked in your PMO office as your Director of Issues Management until 2017, is that correct?
That sounds right, yes.
Are you aware that she was Chief of Staff to Minister Blair in 2021 in the lead-up to the 2021 election campaign?
Yes, that sounds right.
And the Commissioner has heard that a politically sensitive warrant application that would have empowered CSIS to investigate foreign interference languished on Ms. Astravas's desk for approximately 54 days in the lead-up to the 2021 election. Are you aware of that fact?
I believe there are questions about the dates involved.
Does that mean that you disagree with the overall time period of 54 days?
Yes.
Okay. And how long, in your understanding?
My understanding, it was a number of days before it was a number of days within those 54 days before it ever got near Ms. Astravas's desk.
Okay.
But again, these are things that I have learned over the course of the various testimonies over these past days, not anything I was aware of at the time.
Okay, have you heard the figure 54 days at all in connection with these proceedings?
I've heard that you used it yesterday.
Okay, and if that time period is correct, 54 days, have you learned at all, or do you have any understanding as to whether that length of time for the processing of a CSIS application for minister approval for a warrant is ordinary, out of the ordinary, extraordinarily out of the ordinary? Have you formed any view on that?
Because I have, as Prime Minister, absolutely no involvement in the process whereby CSIS is granted warrants, I have no frame to conclude on that. What I can lean on is, I believe the director of CSIS raised that there was no flags about the timelines involved.
Okay. Mr. Blair remains in cabinet today, sir?
Yes.
Okay. And he serves as the Minister of National Defense today, doesn't he?
Yes.
Okay. Just give me a second. And has Minister Blair or anyone in his office at the time that he was Minister for Public Safety faced any consequences for the fact that that warrant application we've come to know did languish in that office for what I'm going to suggest to you is a period of 54 days?
Like I said, the director of CSIS himself testified that he had no issues with the timelines involved, and I can certainly say that I continue to have full confidence in everyone involved.
Okay. I want to switch subjects. You leveled some criticism and professed bewilderment at the leader of the CPC this morning not agreeing to receive a security clearance. Is that correct?
Yes.
Am I correct, sir, that Mr. Poilievre has said that the reason he does not wish to receive the security clearance is because he does not want to be constrained in terms of the use he can make of the information that he would receive?
I don't believe that was his argument. I believe his argument was that he wouldn't be able to talk about the information he received.
How is that different than what I just said?
Because as leader of a political party, you have many, many tools at your disposal to act on information you receive. You can choose to not sign the nomination of a candidate who is under a cloud of suspicion. You can choose to not elevate them to a critic's position. You can choose to not promise to make them a minister one day. You can you can choose which committees they sit on. A leader of a party has many tools that they can use that are not requiring him to speak publicly about his knowledge. The leader of a party has quite a bit of power over what happens within that party, and that's why the ultimate decision maker in a political party should always be the leader.
Are you aware that there are other security cleared individuals within the CPC that can and do receive regular security briefings?
I think you're speaking of Ian Todd, the Chief of Staff?
Among others, yes.
I can't help but imagining how people would react if I sort of sat back and said, well, no, Katie Telford got cleared on this information. She made a determination about who could run for me or not, and I don't need to worry about that sort of stuff. Canadians didn't elect, or Conservative Party members didn't select Mr. Todd to make decisions about who could run for the Conservative Party of Canada. They expect Mr. Poilievre to take those decisions, but he has decided that he doesn't want to take those decisions.
Sir, just over the lunch break, and you didn't mention Mr. Todd at all in the bombshell disclosure that you made today, but just over the lunch break, in light of that, in response to your news this morning that you were aware of a number of CPC parliamentarians and former parliamentarians that are at risk of being compromised by foreign interference, Mr. Todd has advised that he has received a number of top secret briefings from the security establishment, and in none of these briefings has the name of any Conservative parliamentarian or candidate, past or present, been brought to the attention of Mr. Todd. Why is that?
You'd have to ask CSIS for that, but my supposition is that Mr. Todd is not the one who is responsible for determining what candidates can run or not for the Conservative Party of Canada, that it would be the leader. And much of the information that is handed out to various individuals with security clearances is determined on their need-to-know basis.
You indicated today, as I indicated earlier, in a very public forum and in a very public manner, your knowledge of the names of CPC parliamentarians and the risk that they risk being compromised by foreign interference. Am I correct, sir, that one way that you could arrange for those threats to be mitigated is through the use of threat reduction measures under Section 12.1 of the CSIS Act?
Threat reduction measures are tools that CSIS has used regularly in many cases regarding different parliamentarians, and it is very possible that a number of those parliamentarians will have had visits from CSIS and either defensive briefings or others to try and mitigate the risks that they are going through. That is different from a leader choosing to willfully remain ignorant of very serious contentions, including by the NSICOP, that the leadership race that elevated him to leader was compromised by foreign interference.
And if the tool of the TRMs were used, you couldn't use the Leader of the Opposition's reluctance to obtain security clearance as an excuse not to provide that information to the CPC. Isn't that correct?
I'm sorry, I'm not following. Can you rephrase the question?
Sure. If someone wanted to get this information, this information about the names of the parliamentarians, for example, because of some imminent threat to the leader of the CPC, TRMs could be used, and in that event, it wouldn't be necessary for the leader of the CPC to obtain security clearance.
No, you're entirely wrong on that. If you were to know that a certain candidate had a high degree of exposure to foreign interference and vulnerability, either witting or unwitting, giving a threat reduction measure to that candidate would not necessarily, and quite frankly, in my experience, highly unlikely to have the candidate spontaneously decide to step down as either a candidate or a member of parliament and not run in the next election. That is a determination that only a leader can make, looking at the vulnerabilities of that candidate, looking at the behavior, and to use the words of the NSIA, potentially poor judgment or inappropriate behavior or untrustworthiness. Those are the kinds of things that only a leader can actually ensure for the team that they're building, and potentially future ministerial elevations that would then have to run into a security clearance process that would stop them like a brick wall. Knowing that as a leader, as you are hoping to become Prime Minister of this country, would seem to be a very basic bar to hit if you want to take national security seriously.
But the underlying premise of that answer you just gave is that the TRM can only be directed at the person affected and not the leader of the opposition. Isn't that correct? The TRM could be directed to Mr. Poilievre.
The identities of the people involved are themselves classified and available to only those with top secret clearances. So certainly CSIS could go to the leader of the opposition and say, you really have to be careful to instruct all of your MPs to stay away from this country, or to be concerned about diplomats from that country, or not accept money, or not accept support from these particular diplomats. But the TRM would be unable to identify which of those individuals are in question unless the leader chose to get a security clearance to be able to hear those names. And the fact that the leader does not leaves him in a position of being unable to protect the integrity of his party.
I'm going to suggest that you're wrong on your understanding of the law as to what a TRM can and can't do and who it can be directed to. And I'm going to suggest that the fact that you leveled this accusation earlier today and didn't mention the possibility of a TRM was just for the purpose of grandstanding here today.
On the contrary, threat reduction measures are regularly used to highlight to people potential vulnerabilities. But having watched many, having known a number of parliamentarians who went through TRMs, they often come out of TRMs with a general sense of having to be more careful. But specifics are often not given, and there is no guarantee that a TRM to the leader of the party would include the names of the people most at risk or most engaged in potentially problematic activity. And that's why the refusal of the leader to actually access the intelligence on those names is, as I said, bewildering.
Do you agree that often when CSIS or some other security agency shares classified information, the recipient is severely constrained in what he or she can do with that information?
Yes.
Okay. And in fact, your own chief of staff yesterday gave evidence that the recipient of that information would not be able to use that information in any manner. Do you agree with that?
No, I disagree, because the party leader can choose to not allow someone to run for them for any number of reasons, knowing in the back of your mind that this is the real reason, but giving it as an example, I'd actually prefer to have this other person run instead, or you had sketchy business dealings in the past, that means we're not going to go with you. There are all sorts of reasons that do not prove injurious to national security. The leader has a level of power over who runs and what roles they have that doesn't require them to explain themselves. So again, the choice that Mr. Poilievre has made to not avail himself of available information of readily available information to him if he were to get a security clearance and choose to take national security issues seriously is unfortunate and shows a lack of seriousness around national security.
And in your salacious testimony earlier today, you mentioned that you're aware of the names of past and present conservative parliamentarians, former parliamentarians, candidates that are in risk of being compromised by foreign interference. I'd like to ask you, are you aware of the names of any Liberal parliamentarians, former parliamentarians or candidates that are at risk of being compromised by FI?
Yes, and for other parties as well, because I have access to large amounts of information.
Right. You didn't mention those today, right?
We spent an entire session the last time we had a public hearing talking about concerns and named individuals that that CSIS and intelligence agencies had within the Liberal Party. Don Valley North comes to mind as a riding. So as I have said many times, there have been actions taken and choices made based on information we got because I had that security clearance.
Right.
Mr. Polyev has decided not to get that security clearance, so he can't even know how to begin or not to make decisions regarding that information.
Okay, so you've acknowledged Mr. Dong. I want to see if you can help us with, in connection with the warrant application that we were talking about earlier, that I was talking about earlier with you. Can you confirm that either the target of the information or one or more of the individuals on the Van Wienen list were Liberal operatives, sir?
We object to that question on the grounds of national security.
With all due respect, Madam Commissioner, when it suits the Prime Minister's purpose to say that there are Conservatives on a list that he can discuss or he can't discuss, that's fine. But when I ask for confirmation if there are Liberal operatives that are on a list,
I said yes.
My friends, well, I'm asking you in particular on that list there.
But that is
on the warrant or on the Van Wienen list?
The Prime Minister has absolutely no engagement or authorities or involvement in the granting of CSIS warrants. That's a very different thing than concerns about parliamentarians who may have been exposed to foreign influence. And your attempts to conflate them are simply ineffective.
Well, you're attempting to evade the question. I just asked you if any of the names there were Liberal operatives, not whether you could or couldn't do anything about it. That's all I'm asking for confirmation of.
Well, I'm not sure what we're talking about. If we're talking about the warrant, anything that might be related to the warrant, then there's an objection to the question. If we're talking about some other list, then ask the question about the other list.
So it's about the warrant?
It's about the target of the warrant or the people that are named in the Van Wienen list that accompany the warrant.
So the questions are noted. I have no choice, as you know, and we'll see whether the Commission will pursue these questions or not.
Thank you, Madam Commissioner.
Thank you.
Thank you, Prime Minister.
Thank you.
So we'll take the break. I think 15 minutes will be okay. So we'll come back at 3:50.
Order, please. À l'ordre, s'il vous plaît. This sitting of the Commission is now in recess until 3:15. Cette séance de la Commission est maintenant suspendue jusqu'à 15h15.
ਸ਼ਬਦ ਜੰਗ ਦੇ ਵਿੱਚ ਸਲਾਮ ਹੈ ਤੁਹਾਨੂੰ ਲੜੇ ਹੋ ਨੰਗੇ ਧੜ ਲੜੇ ਹੋ ਬਿਨਾਂ ਕਿਸੇ ਮਦਦ ਦੇ ਉਹ ਜਿਹੜਾ ਸਿਸਟਮ ਹੈ ਨਾ ਉਹਦੇ ਕੋਲ ਇੱਕ ਟੀਮ ਹੁੰਦੀ ਹੈ ਤਨਖਾਹਾਂ ਦੇ ਉੱਤੇ ਕੰਮ ਕਰਦੀ ਹੁੰਦੀ ਹੈ ਜਿਹੜੇ ਬਕਾਇਦਾ ਤੌਰ ਦੇ ਉੱਤੇ ਚੁਣੇ ਜਾਂਦੇ ਹੁੰਦੇ ਨੇ ਉਹ ਪੂਰਾ ਮੁਲਕ ਉਹ ਇੱਕ ਸਟੇਟ ਉਹ ਸਿਸਟਮ ਇੱਕ ਤੁਹਾਡੇ ਖਿਲਾਫ ਸਾਰੇ ਰਿਸੋਰਸਿਸ ਅਸਾਸੇ ਇਕੱਠੇ ਕਰਕੇ ਤੁਹਾਡੇ ਖਿਲਾਫ ਲੜ ਰਿਹਾ ਉਹ ਜੰਗ ਉਹ ਇੱਕ ਬਿਰਤਾਂਤ ਕ੍ਰੀਏਟ ਕਰਦਾ ਤੁਹਾਡੇ ਖਿਲਾਫ ਤੇ ਤੁਸੀਂ ਨੰਗੇ ਧੜ ਓਹ ਵਾਹਿਗੁਰੂ ਉਸ ਜੰਗ ਨੂੰ ਲੜਿਆ ਤੁਸੀਂ ਸ਼ਬਦਾਂ ਦੀ ਚੋਣ ਕੀਤੀ ਤੁਸੀਂ ਅਜਿਹੇ ਸ਼ਬਦਾਂ ਦੀ ਚੋਣ ਕੀਤੀ ਜਿਹੜੇ ਬਿਲਕੁਲ ਉਸ ਵਾਰ ਨੂੰ ਖੁੰਡਿਆਂ ਕਰਦੇ ਨੇ, ਉਸ ਵਾਰ ਨੂੰ ਤੋੜਦੇ ਨੇ, ਉਸ ਵਾਰ ਨੂੰ ਜਿਹੜਾ ਹੈ ਉਹ ਨਕਾਰਾ ਕਰਦੇ ਨੇ ਉਹ, ਤੇ ਤੁਸੀਂ ਉਸ ਦੇ ਵਿੱਚ ਜੇਤੂ ਹੋ ਕੇ ਨਿਕਲਦੇ ਹੋ। ਮੈਂ ਕਹਿੰਦਾ ਐਸੇ ਤਰੀਕੇ ਨਾਲ ਤੁਹਾਨੂੰ ਲੜਨਾ ਪਏਗਾ, ਲਗਾਤਾਰ ਲੜਨਾ ਪਏਗਾ। ਮਹਿਜ਼ ਇਹ ਕੁਝ ਸਮੇਂ ਲਈ ਅਜਿਹੀਆਂ ਖਬਰਾਂ ਹੋ ਸਕਦੀਆਂ ਨੇ ਜਿਹੜੀਆਂ ਸਾਡੇ ਮਨ ਨੂੰ ਸਕੂਨ ਦਿੰਦੀਆਂ ਹੋਣ। ਇਹ ਕੁਝ ਸਮੇਂ ਲਈ ਅਜਿਹੀਆਂ ਖਬਰਾਂ ਹੋ ਸਕਦੀਆਂ ਨੇ